Welcome to Dolly Talk. This is Dolly. How late will Dolly be? Oh, come on. Only 2 minutes late. Hey, Johnny, Justin, how are you? Mavka. It's just a short appearance today, just the conference, but we do get to see our boy Buster. He is back. So we're going to start that, and then we'll do some more Judge Simpson, because it was just a probable cause conference today. So let's see. How is everybody doing?
Thank you, ma'am. Court calls the case, People versus Buster Robbins.
Woohoo!
Good morning, Your Honor. Tim Turkles on behalf of Mr. Robbins.
Aw, look at our boy.
All right. Your name, sir?
Buster Robbins.
Thank you. What are we doing?
Your Honor, it's my understanding that the defense is wanting to schedule a preliminary exam in the matter.
All right. Counsel, is that correct?
That's correct, Your Honor.
All right. Is all discovery complete?
We believe so, Your Honor.
Your Honor, I was talking to defense counsel, and while there may be some stipulations that speed up the exam, this does have the potential, given the age of the case, to be a somewhat lengthy exam.
Oh. Okay. Well, let's see.
It'll be a lengthy.
I'll let you try to coordinate. Judge, will March 4th work?
Judge, the defense won't be available on March 4th. We were hoping for March 17th, the week of March 17th.
Pardon?
Oh, God.
The defense won't be available that date. We were hoping for the week of March 17th.
Well, Buster's
Do you have
available.
any objection to the March 17th week?
If it's in the beginning half of the week, we should be okay.
That's fine, Judge.
I don't know what that means.
Our lab analyst is out starting the 21st. So if it's March 17th.
Oh, well, we'll set it for March 18th. Preliminary examination in person, March 18th, 2025, 9 a.m. in person before Judge Barr.
All right. Judge Barr.
Thank you, Your Honor.
Now,
Thank you. Bond continued. Thank you, sir.
not going to lie, that was kind of disappointing. I was hoping for a little more out of Buster. But Judge Barr on the 18th at 9 a.m. So now I have to look and try to get a court feed in that courtroom. I wish it was in front of Simpson. But I will ask David and see what we can find. He has a YouTube channel, but I don't know if he actually streams anything on it. That's the only problem. Some judges don't. So let's go back to
The whole
beginning.
truth and nothing but the truth, so help you God.
I do.
State your name for the record.
Stephanie Joy Woodall.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
I understand that.
All right. And understanding that, you still wish to plead guilty?
I do wish to plead guilty.
All right. I should also advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I understand.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or remain silent and not have that silence used against you, and giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, man?
I understand.
You understand you're giving up your right to appeal of right.
I understand.
Are you on probation or parole? You are not.
I am not.
Correct. Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to flee?
No.
Anybody threatened you or coerced you?
No.
You're doing this voluntarily
I am doing it voluntarily.
Ooh.
and of your own free will,
Yes.
and because you believe that you're guilty?
Yes.
April 12, 2023, at the location of 3025 Michigan Avenue, East Michigan Avenue in Ypsilanti Township, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
I did.
Aw.
Had you used it?
Yes.
And did you know what you were using was fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Yes,
Did
Your
you have
Honor.
a counterfeit $20 bill in your
Court will
possession?
accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
13th at 10 a.m. for Judge Washington.
March 13, 2025.
What the hell is going on with Rick Astley's hair on the left? Middle left there. Good Lord, dude.
10 a.m. Judge Washington. Bond will continue. Thank you.
Thank you, Your
Thank
Honor.
you.
Ms. Woodall?
Court does call the case of the people versus Jerry Ashley.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Chinazi Carey, I can really on behalf of Mr. Jerry Ashley. Mr. Ashley, put your name for the record, please.
Jerry Ashley.
Thank you.
Your Honor, if I could just speak to my client very briefly. Mr. Ashley, we're going to adjourn today. The prosecutor and I are still working on a negotiation, okay?
Okay.
So, Your Honor, we'd be requesting an adjournment.
Probable cause conference without objection will be adjourned March 6, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Ashley. Court does call the cases of the people versus Dale Miller, 3 cases.
Dale Miller. Let me
Andrew Childers
guess.
appearing on behalf of the people.
Meth?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller. Mr. Miller, will you please state your name for the record?
Dale Miller.
Thank you.
Got him.
Your Honor, the court should be in receipt of competency referral on each of the files.
Got it.
Thank you.
Requesting a forensic evaluation on all of these matters.
Yes.
Court will order a forensic evaluation. I will set a comp hearing
15th at 10 a.m.
May 15th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Sir? Yeah, that's fine. Court calls case People versus Sean Almond.
Favorite kind of nut.
Christy Berta from the Attorney General's Office on behalf of the people.
Good morning.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Almond, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Sean Almond.
I got it. He's waiving.
That is correct, Your Honor.
Mr. Almond, you're waiving your right to a preliminary examination. Is that correct?
Yes, sir.
You understand that that is a proceeding where the people would have to show by probable cause that the offense is alleged, or the offense alleged was committed and that you committed it.
I knew you'd like her, man.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Pate.
Thank you, Your Honor. We acknowledge receipt of the information. Waive formal reading. My client stands mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
At 1:30 before Judge Simpson.
April 8th, 2025, 1:30, Judge Conkey.
Thank you, Your Honor.
Bond will continue.
Thank you, Your Honor.
Thank you.
Mr. Almond.
Thank you.
Anything for us, Ronnie?
Court does call the case of the People versus John Boer. 2 cases.
Good morning, Your Honor. Ashley Lonnie for the people of both matters.
Good morning, Your Honor. Good to see you. Robert Ellman on behalf of Mr. Boyer in both matters. Mr. Boyer, can you,
Switch side.
sorry, can you please say your name for the record, Mr. Boyer?
John Michael Boyer.
All right. I have 2 resolution or 2 plea forms.
That's correct, Your Honor. In case 24F31637FY, the defendant is going to be pleading no contest to an added count 2 of attempted resisting or obstructing a police officer, 1-year misdemeanor and or $1,000 fine. In exchange for that plea, count 1, fleeing and eluding in the 3rd degree, the 5-year felony will be dismissed. Defendant must enter into 15th District Court's mental health court. I understand he's already been accepted. In the other file, 23F0062FY, the defendant is going to be pleading to an added count 3 of attempt use of self-defense spray, the 1-year misdemeanor, contrary to 750224D2. In exchange for that, counts 1 and 2, both FA will be dismissed, contrary to 75082. In that file, the defendant must also enter into a complete mental health treatment report.
And that is my understanding of the agreement as well, Your Honor. And I believe these will be no contest pleas, and you should have both reports in your file there.
You and I have looked at them. So, all right. May I have him sworn?
Raise your right hand.
Right hand.
Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth self you got?
I always want somebody to say
State your
no.
name.
John Michael Boyer.
All right. The Boyer, it's this court's understanding that you are going to be pleading no contest to 2 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
The first charge is that of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is the offense of attempted use of a self-defense spray. That is also a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in 1483 District Court.
Yes, Your Honor.
Basis for the no contest, please.
Potential civil liability, Your Honor.
All right. Sir, to the charge of attempted resisting and obstructing, how do you plead?
No contest.
To the charge of attempted use of a self-defense spray, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal over.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
Court has been provided 2 police reports. First, in the case ending in 1637, the court has been provided and has reviewed Chelsea Police Department report for their case number 244277. And in the other matter, the court has been provided
Really, by friends?
Chelsea PD report for their case number 24240. Any objection to the court having reviewed those reports?
No, Your Honor.
How does that work? How are you immune?
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
The court will accept the defendant's plea in case ending in 1637. Count 2, count 1 is dismissed. In the other matter, the court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and reports are ordered at 1483 probation. Sentencing in these cases will be
March 10th at 9 a.m. before Judge Freshour.
March 10th, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor. May we address bond very briefly?
Very briefly.
Your Honor, Mr. Boer has been in custody most recently since right before Christmas.
Aw.
I don't believe his mother is here today, but she's
Aw.
been here in the past. He does live with his mother at home. She's assured me that
He's a good
she
boy.
will make sure that he does everything he needs to do. I think possibly a release on a GPS tether could be appropriate in this matter, given the resolution.
He's going into the mental health court.
Yes, Your
Is
Honor.
that correct?
That's correct, Your Honor. And in the older file, which is the file that just led to the use of self-defense spray, he was gone on bench for several months, so I'm actually opposed to any change in his bond at this time. If the mental health treatment court decides that he's eligible and good for release, I wouldn't have a problem with Mr. Almond contacting Judge Freshour's court and the APA assigned there to arrange that. But at this time, I'm going to oppose any change in bond.
All right. And I would have to agree with that. I think I'll let the mental health court make the determination as to release and under what conditions. So motion for bond reduction at this time is denied.
Thank you, Your Honor.
Thank you.
How are you doing, Mads?
Court does call the case of the people versus Neil Hines.
Vielheim.
Christy Berta from the Attorney General's Office for the People.
Good morning, Ashley Moten, Assistant Public Defender, appearing on behalf of Mr. Hines, who appears on Zoom. Please state your name, Mr. Hines.
Neil Hines.
State your name.
Neil Hines.
He did.
Oh, I'm sorry to say good morning. We're requesting a 1-week adjournment. The payments have been made, but they haven't been posted to his account, and then he'll be able to accept the plea offer.
What do you mean?
I'm sorry?
Just hasn't gone all the way through to post to the account?
Yes. And also, his bond should have been applied to the case, and it has not as of today, as far as I know.
Yeah, I believe the order was just submitted to the court for execution. The balance is quite low. I understand he did make a payment this week that is not reflected on the MISIS report as of yesterday. So I believe I don't object to an adjournment, but I think 1 week is not enough. I would ask the court for 2 or 3 weeks.
Oh, okay, very good. That's what I was wondering, timing on that.
Okay.
If he's making the payments of doing that, probable cause, I'll adjourn to March 6, 2025, 9 a.m.
Thank you.
Thank you, Your Honor.
Thank you. Bye. Court does call the case of the people versus Logan Cyrus.
People, Your Honor.
Mr. Burns Senior.
Well,
your name, sir?
Logan Cyrus.
Thank you.
Your Honor.
Yes. Yes.
Tony, I believe is in a Zoom.
All right.
Good morning, Your Honor. Sorry about that. Sam Bernstein with and on behalf of Mr. Cyrus was present.
All right. He's already stated his name. What are we doing?
We're asking the court for an exam, please. Discovery is complete.
And people would have their witnesses available the 25th.
We'll do our best, Your Honor.
Preliminary examination will be in person, February 25th, 2025, 9 a.m. That is before me. Bond will continue. Thank you. Court calls the cases of the people versus Samantha Warren. 4 cases.
Andrew Childers appearing on behalf of the people.
Good morning, Edward Drukas on behalf of Samantha Warren in 7-11. I assisted her with trying to get arraignments on all 3 other cases. I think the court. I assisted her with getting the other cases arraigned today.
Are these arraignments? Where is she?
I'm on 711. We'll need, I believe the public defender will step in on the other cases.
Yeah.
Okay. Are we?
Second this one.
We got anything going on here,
What
Judge?
is your case number?
This. Oh, 5099. I did write it down incorrect.
Got it. Okay. All right, Ms. Warren. You are before the court on 3 other charges, or 3 other files. All right. Let me just go through a brief.
Wait, is that a
arraignment with you
woman
on
at the
that.
bottom?
In the case ending in 5522, you are charged with the offense of home invasion in the 3rd degree. That's a felony punishable by up to 5 years incarceration, a $2,000 fine plus court costs. That is alleged to have occurred on January 6, 2025 at the location of 508 South Division Street in the city of Ann Arbor. Do you understand the nature of those charges, or that charge and the discipline penalty?
Yes, Your Honor.
All right. In the case ending in 5517, you are before the court on a complaint that alleges that on or about January 13, 2025, at the location of 336 South State Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did commit the offense of stealing or retaining without consent a financial transaction device. Do you understand the nature of that that charge, ma'am?
Yes, Your Honor.
That's a felony punishable by up to 4 years incarceration and a $5,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
In the file ending in 5516, you are before the court on an offense that is alleged to have occurred on January 10th, 2025 at the location of 350 Thompson Street in the city of Ann Arbor, Washtenaw County, state of Michigan. That offense being home invasion in the 2nd degree. Do you understand the nature of that charge, ma'am?
Yes, Your Honor.
That is a felony punishable by up to 15 years and a $3,000 fine plus court costs. Do you understand all of that, ma'am?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, Your Honor.
These are public defender cases.
Hannah Mackey on behalf of Mr.
You wait for further formal reading.
We do, Your Honor.
And how does your client plead?
Not guilty, Your Honor.
Defendant having waived formal reading, pleading not guilty, court will enter that not guilty plea. Demanding a preliminary examination, I will set this for probable cause. I will set. Are you looking for an adjournment?
We are.
I'm looking for an adjournment to
waive timelines.
Yes, we do.
What's Ronnie doing
I will
there?
set a probable cause conference in these matters, adjourning the one and setting the other one for March 6, 2025, 9 a.m. And at that time, we'll set a preliminary examination when the case is ready. Anything else to bond?
No, Your Honor.
Nice, Mavka.
None for us, Your Honor.
Bond in these cases will be set in the amount of a $10,000 personal recognizance bond. All other standard conditions, including no assault behavior or possession of weapons. She's not to possess or consume any alcohol, recreational marijuana, or any illegal drug. With respect to, I'm also going to enter that she is not to go to the stated addresses in the one case of 508 South Division in the city of Ann Arbor. And in the other case, it's the State Street address.
And Your Honor, there's a co-defendant. He's currently in the jail, so it's not. I'm not terribly concerned, but I would ask for a no contact with the co-defendant, Cedric Green.
Cedric Green?
Yes.
Yeah. Any response to that?
And we represent Cedric currently, like he's a co-defendant.
Yeah, he was up for prelim on Tuesday, and we had to adjourn it. But yes, your office, Miss Pate, I believe, was representing him on Tuesday.
Got it.
I believe there may be a conflict.
You think? All right. So I think his name was with an E at the end.
I think it's S-E-A-O. Yes, I believe you're correct.
All right.
His first name.
What I will do is I will order no contact with Cedric Green on all of these matters also.
Yes, Your Honor.
Okay.
Hey, Hella.
All right. This one is self-vision. The other one, I just need it from the complaint
Okay. And
on here.
I'll confirm the spelling of the name as well.
How are you?
Okay.
And if you want us to go down to MAC and have them appoint somebody right away.
Pardon?
If you want us to go down to MAC and have us appoint somebody, have them appoint somebody.
If you think that it's a conflict, they can do that, and then we can change the files, but she'd have to wait because I'd have to know that. I think it probably would be wise so that on the 6th, whatever's going to happen is going to potentially happen. So, Ms. Warren, I'm going to ask you to wait.
Yes, Your Honor.
I'm going to ask you to wait online. The public defender acknowledges that there is a conflict in them representing you at this point, okay? So what's going to
Yes, Your
happen
Honor.
is they're going to go down, check with the MAC office. We will then, there'll be a new attorney appointed. I'll sign an order of withdrawal for the PD. A new attorney will be appointed, but I need you to wait so I can inform you who that is.
Okay, I'll do that now.
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
That's adjourned. Yes.
Oh, perfect.
What now?
No, nothing. This is your next case.
That Samantha just put on that
Court
arm
does
brace
call the
for
case,
court.
People versus Mason Hurst.
Actually, a lot of people.
Public defender Powell Nicholas Buckovich for Mr. Hurst, who's appearing again in hearings.
Mason.
Mr. Hurst, can you state your name, please?
Mason Hurst.
What are we doing on this today?
Yesterday, I received a competency report that indicating that Mr. Hurst is competent to stand trial.
All right.
Not sure if the court was in the receipt of that report. I received it around 2 p.m. yesterday.
I don't have a copy.
How much want to bet this guy got locked in his lockers in law school?
I can forward a copy to the court.
All right. Mr. Hurst, well, yeah, get me a copy so I can review it, and then we can take care of this
Sorry,
case
Matt.
today.
Okay, cool.
So, Mr. Hurst, I'm going to pass your matter briefly. They're going to have to give me a copy of the report so I can look at it. Thank you. Court calls case People versus Jacob Jackson.
Christy Berta from the Attorney General's Office for the People.
Thank you.
Ashley Moten, Assistant Public Defender, appearing on behalf of Mr. Jackson.
Aw, poor
Jacob
Hella.
Jackson.
All right. You're requesting an adjournment?
Yes, please. If we could get about a month, if possible.
Pardon?
Could we get about a month?
Need a whole month?
Yes.
He's going to make a payment and there's a plea.
Yes, he has to make a significant payment that he believes that he should be able to make within a month, so he can accept that plea.
Any objection to the 13th on behalf of the Attorney General?
No, Your Honor.
Probable cause conference will be adjourned March 15th, 2025, 9 a.m. Bond continued.
Thank you.
The
Thank
court
you.
said the 13th or the 15th, Your
Oh,
Honor.
God. Christy,
The 13th.
Thank you.
get the wax
Thank
out of
you.
your earpods.
Court does call the case People versus Taylor Lewis.
And then on behalf of people,
Morning, on behalf of Mr. Lewis, who's approaching. Taylor, please name the record, please.
Taylor Lewis.
Thank you.
Judge, can we set this for exam, please?
While discovery is complete,
Yes, Your Honor.
people have their witnesses available the 25th.
do our best, Your Honor.
You'll do your best.
Preliminary examination in person, February 25th, 2025. 9 a.m. That is before Judge Barr.
Oh, another
May I
one
address
before
the
Barr.
tether issue very briefly?
Briefly.
Judge, I don't think the prosecutor's going to object to this. My client's wearing a tether. We've discussed this before. She's a top chef at Ford Motor Company, which is extremely professionally embarrassing to her. She lives in Wayne County. The alleged victim lives in Ann Arbor. It's about 40 minutes apart. There's been no contact on her side. The victim is continually calling her. We like to repair the relationship. That all being said, my client has not answered any phone calls. She's not a threat. She will not go to Ann Arbor except to meet here in the courtroom, Judge. And she's asking that because she's a professional at Ford Motor Company. It's truly embarrassing for her to be walking around as a chef wearing a tether.
Wait, she's a chef? She's a chef at Ford Motor Company? Okay. Well, whatever pays the bills, I guess. I don't want to know what they're using for oil.
You allow her to take that tether off.
I suppose incarceration is less embarrassing.
I'm sorry.
Never mind. Response from the people.
What a dick answer. Oh, I love that. I suppose incarceration is less embarrassing. Do they make their own food there?
Well, other than court proceedings, she has no reason to be in Washington County. Is that right?
No, I don't.
Matt. I don't know, Mads. Aren't you only familiar with IKEA?
We're going to need an order in. I will order that the tether can be removed effective today. The defendant is not to enter Washington County under any circumstances except for court-related proceedings.
Thank you, Judge.
Yes, sir.
This is probably a stupid question, but that also
Probably is. Go ahead.
seeing me at my office at Ypsilanti. I mean,
That would seem to be a court-related proceeding.
that's what I thought. Thanks, Judge. Really appreciate your consideration.
Court calls case People versus Cameron Curtis.
The attorney will be looking for. Stephanie Cannon on behalf of Mr. Curtis, who's appearing to my right. Mr. Curtis, could you please state your name for the witness?
Cameron Gage Curtis.
We're requesting an adjournment.
Yes, Your Honor. We're just requesting a 2-week adjournment to do some additional investigation and negotiations regarding his matter.
Without objection, probable cause conference will be adjourned to February 27th, 2025, 9 a.m.
Your Honor, may I briefly address bond?
Briefly.
Your Honor, I am not asking that my client just be released. His primary issue is substance abuse. He just wants to get back into treatment. I'm just asking if the court would be so inclined to allow him to be released into inpatient treatment.
Any response from the people?
At this time, the people would reject. This defendant had a bench warrant from out of circuit court for failure to appear in front of Judge Slay. This is an R&O where he ran from the officers. So at this point, people would object to any.
Well, this is the court primary practices. I understand what the people's position may be, but if his primary issue is substance abuse, I would permit, and counsel, you can prepare an order that he can be released to inpatient treatment if a bed becomes available, but on a GPS tether.
Thank you, Your Honor.
Court does call the case of People versus Mark Stewart.
Good morning, Your Honor. Robert Elman on behalf of Mr. Stewart. Your Honor, I know you have a busy docket today, but will you please briefly approach?
Okay, suck up.
You just want to mess up my day. Come on.
Thank you.
Amai, you want to, you gonna just take a nap here? All right, that's cool. Don't let court, interrupt your busy beauty sleep. Got to get those 8 hours in, I guess.
Record should reflect we had a bench conference in this case. Court will adjourn this probable cause conference out to February 27th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you, Your Honor.
Yeah, she does have the look of like
Court
she's
does call
looking
cases of the People versus Dion Baldwin.
down and she tied it onto a table.
Oh, Your Honor. We're good.
Oh, that'd be great if she starts snoring. Oh, and I guess
Your Honor,
the prison food slot is accused of some crime as well.
You're requesting an adjournment?
I am, and I would like to approach with the prosecutor if possible.
Oh, geez.
Why? Never mind. Come on.
Hey, Amal, rise and shine, princess. Oh, something I said? Oh, she just fingered the phone. Okay. Yeah, take your time.
Case. Record should reflect we've got a bench conference in this case, and you're requesting a preliminary examination.
Yes, Your Honor.
And discovery is complete, and that people will have their witnesses to the extent that it is necessary. So I will set a preliminary examination in person, February 25th, 2025, 9 a.m. That will be, these will be before me.
Ah, Ronnie's getting
As
her
the
face
bond in
put
this
on.
case, you're requesting his release at this time.
Yes, Your Honor.
And my understanding with the conditions, there's no objection from the people.
That's correct, Your Honor.
All right. So I will grant in both of these cases, the defendant's request for release. I'll set a bond in the amount of a $10,000 personal cognizance bond. I will also order standard supervision through community corrections, as well as a GPS location tracking tether. That all those have to be placed on prior to his release. Anything further?
Jeez, Ronnie.
Not on behalf of the people.
All right, thank you.
Thanks.
Can you fill that in?
Yep, and I can finish it.
This is my new channel I'm starting. Dolly Talk does
People
makeup.
versus Christopher Cucola.
Coca-Cola?
Assistant Public Defender Jay Bellinger on behalf of Mr. Cucola, who appears via Zoom from Bureau of Prisons, Your Honor. I believe he appears via telephone.
Well, if he's really skinny, we can call him Diet Coca-Cola.
Cucola, can you
Coca-Cola.
Can you unmute, sir? I'm not. He's muted. I don't know what their setup is there. If you have access to the keypad for the phone, hit start.
I actually am starting a second channel I need to work on it more. I'm going to react to court, do weird things on this channel, and then just do like my Fleischer coverage and other court streams like the raw video and everything. Maybe some videos I'll do on my other channel. I think I'm going to call it Daily Docket. So, still a work in progress, but Dolly Delicious could be my track name. Jesus. Hey, Daddy.
6 to unmute Mr. Cocola.
With makeup.
And Your Honor.
Oh, he just did.
Your Honor, you got us?
You got it.
All right, we're here. I have this is unit manager help. I have Mr. Kukula here for you, sir.
All righty, thank you.
And Your Honor, it's my understanding there's going to be a plea today. I don't believe the box was checked. I apologize for that. It's going to be a guilty plea. And my understanding of the offer is that count 1 will be amended to a use. He'd be pleading as charged to count 2, the reckless, and count 3, the DWLS, would be dismissed.
And called excited Dolly.
So he's going to be pleading guilty to the charge of reckless driving, the stated count, the added count 4 of use of a Schedule 1 narcotic, a 1-year offense. Upon a successful plea, that those charges, counts 1 and 3, would be dismissed.
That's my understanding of the offer. Mr. Kukala, did you hear that?
Yes, sir.
Is that your understanding of the offer as well?
Yes, it is. Absolutely.
All right.
All right. Mr. Cocola, I'm going to have to ask you to speak up a little bit for me, okay?
Yes, sir.
He sounds like Donald Trump.
Thank you. All right. And there's no objection from either.
The hell? Sorry, guys. My browser tab just crashed.
Phone.
No, Your Honor, I can recognize his voice from our prior conversation.
All right, very good. Why are you moving furniture? Never mind. We'll talk in a minute.
I didn't do anything that time.
Can you raise your right hand?
Yes, sir.
Yes, sir.
Do you
His
solemnly
best court
swear or affirm
appearance.
testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
Absolutely.
All right. State your name for the record, please,
I'm going to
sir.
put a tariff on you,
My
Judge.
name is Christopher Nicholas Cocola.
The best Coca-Cola. I only
Sir,
drink
it is this
Diet
court's understanding that
Coca-Cola.
you are going to plead guilty to 2 misdemeanor charges. Is that your understanding?
God damn it. Sorry, guys. Apparently I'm out of memory. So that would be why. One sec, guys. Oh. Why is YouTube downloader? Okay, that would explain it. Sorry, guys. It's a buffer overflow. Okay. Problem solved. Did I really just say problem solved and it fucking yeeted me again? Okay, last time then I'm going to try changing. God damn it, Justin. Was that like perfect timing or what? Dolly does that. God damn it. No, I'm not reboot. No, I don't want to reboot. Oh, shut up, Mavka. God damn it. Okay, I'm going to like... God damn it. That was perfect. Thank God David isn't here for that. Close some more shit. Okay. Good. All right. Stay, browser. Stay. Stay. Okay. Start.
Of reckless
Good boy.
driving. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
The other charge is an added count 4 of use of a Schedule 1 narcotic. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, Your Honor.
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
Yes, Your Honor.
All right. Understanding all of that, do you still wish to plead guilty?
I do.
To the charge of reckless driving, how do you plead?
Guilty.
To the charge of use of a Schedule 1 narcotic, how do you plead?
Guilty.
Now, you
Nobody
understand that
uses
by pleading
narcotics
guilty,
like
you will
I
not have a
do.
trial of any
I know
kind.
narcotics, the best of narcotics.
Yes, I do.
All right. You gave permission or did sign an advice of rights form, is that correct?
Yes, Your Honor.
All right. Do you have any questions regarding any of the rights that were explained to you?
I do not.
You understand, sir, that by entering this plea, you're waiving all of your trial rights?
I do. Yes, sir.
All right. You understand also, sir, you're giving up your right to appeal of right.
I do. Yes, Your Honor.
Are you on probation or parole? You are not.
I am not. I'm currently incarcerated in the Federal Bureau of Prisons.
Thank you, sir. Has anybody promised you anything?
I had a felony in
other
New
than what's been
York.
stated here today on the record to get you to
It was a rigged
plead
trial.
to these charges?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
Absolutely not.
Just the corrupt DOJ.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes,
And because you believe that you're guilty of these offenses?
that's correct.
December 24, 2020, at the location of Michigan Avenue near I-94, Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Did you operate, how were you operating that motor vehicle that makes you think that you were driving recklessly, sir?
I grabbed it from the
I
Secret
believe the
Service
conditions of the
agent
road, it was,
and yelled
it
at him
was
to take me to the
It
Capitol.
was winter time, and I was speeding.
You were driving too fast for the conditions?
Yes, sir. I'm not aware of the speed I was actually going, but I believe too fast for the conditions. That's correct.
All right. And you would admit that you were driving in a willful or wanton fashion with
After
disregard
inciting
for
that
the safety of
insurrection.
any other persons or property. Is that correct?
Yes, Your Honor.
All right. And on that same date, had you used fentanyl?
Whoa.
No, I don't believe I had use on that day.
Hey, were you in possession of fentanyl?
Yeah, I was in possession of pills, Your Honor. Yes.
You were in possession of pills?
Yes, Your Honor.
Oh.
What kind of pills were you in possession of?
To my knowledge, they were Percocet.
The best
They were
Percocet?
Schedule
Yes,
one.
sir.
All right. And you didn't have authority or a prescription to have those pills, did you, sir?
No, sir.
And you knew that you had them?
Yes, indeed, I did.
All right. Accepting the higher charge for the added count 4. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 4. Counts 1 and 3 are dismissed. Pre-sentence investigation and report is ordered at 14 probation. Sentencing in this matter will be March 13, 2025, 10 a.m., Judge Washington.
Can't believe Donald Trump is
March
doing
13th.
fentanyl.
Okay,
Yes, sir.
one moment. March 13th at, what time did you say? I apologize.
It's at 10 a.m.
10 a.m. Okay.
Yes, they'll have to do a writ to get you on Zoom, or get you logged in, so that date might change a little bit.
And Your Honor, if I may, I believe Mr. Kukola has a number of other matters before the 14B court, and I did inform him that once that court knows of this sentencing, they should pull his other cases so that he can schedule and get those cleared.
Got it.
Percocet.
Very good. Thank you.
If I could please add one thing, I know I'm in.
Oh boy. Percocet is basically, it's like a mixture of opiates and Tylenol. It's not like pure oxycodone. Hold on. Excuse me. Sorry. Just sneezed. Yeah, it's an opiate. It just has Tylenol in there, so you can't like take too much without screwing up your liver.
Open court.
Not that I'm an expert.
I also have a charge in 15th District. Being in the FBOP, it's really hard to relay these things. So will that be addressed then as well? And the only thing secondly is, could you guys fax over to my counselor any court dates or any outcome of this so that they're aware of what...
Your counsel may be able to find other court dates. I don't have the 15th District Court files here.
Okay. I will email the Bureau of Prisons, Mr. Kukola, with regard to your sentencing on this, and I will contact my office to see if there is any scheduled date for you out of the 15th.
Thank you so much. I really appreciate that.
Aww.
All right. You guys have a great day.
Thank you.
Thank you, Your Honor.
Court calls the case. People versus Demetrius Estelle.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Estelle. Will you state your name for the record?
Demetrius Estelle.
Thank you.
Your Honor, we're asking that this matter be set for a preliminary exam.
And discovery is complete.
To our knowledge, yes.
And will the people have their witnesses available the 25th?
We'll do our best.
Preliminary exam in person will be set February 25th, 2025, 9 a.m. That will be before Judge Boer.
Oh, another one.
Bond will continue.
Thank you.
Thank you.
Ronnie, still doing your makeup, sweetie?
Court does call the case People versus Amanda Abure.
Ashley Lonnie for the people.
Amanda Hug and Kiss.
On behalf of Ms. Abure, who should be hearing via Zoom.
Ms. Abure? Is she there?
Ronnie, this better not be a public job.
Your Honor, I did try to get in contact with Ms. Abure via phone and email and have been unable to reach out. I consider she had a court date yesterday in 15th, and there may have been indication that she may be currently in treatment. However, I was not able to get confirmation before today's court date, so I will be asking for an adjournment. She obviously did request a Zoom hearing with her counsel at arraignment. She did intend to be here today.
Okay. Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of 10,000 cash surety. That warrant will issue immediately.
Hello? Hello?
Hello?
Oh.
Hello, who are you?
Did you get your beauty sleep?
Okay, Tom.
You're Miss Kisham. We didn't call your case, but hello.
Oh, sorry, I just woke up, Your Honor.
If you want to.
Well, good to know she's still alive.
Court recalls the case of the People versus Hurst.
Ashley Lonnie for the people.
Public Defender Fellow Nicholas Buckovich on behalf of Mr. Hurst.
Well, she's really going at them brows.
Mr. Hurst, can you state your name, please, again, sir?
Mason James Hurst.
All right. Court is in receipt of the report and has reviewed same. Any additional evidence from defense?
No additional evidence, Your Honor. We stipulate to the findings in the report.
There's nothing from the people, Your Honor, either. We would stipulate to the findings in the report and ask the court to enter an order. You need to have competent stand trial at this time.
court, after a review of that report, would find that based on that evidence that the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I've signed the order. What do you wish to set for?
Are you sure Ronnie's competent enough to do her makeup?
Matters with my client yesterday via Zoom, and he would like to set this matter for a preliminary exam. To my knowledge, we do have all media.
People have their witnesses. That's going to be a problem because they've probably been waiting. So
I'm guessing Ronnie's in order.
Yes, Your Honor. Because the defendant is at the Wayne County Jail, I would request at least 3 weeks so we can do an in-person transportation for it.
Well, how do we do this? I'll set preliminary examination in this matter in person. That will be March 11th before Judge Washington.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Gonna have the best filter in the world.
Continue. Court calls case People versus Cody Lee Jolly.
Aw. Let's see if he's happy.
He's in Zoom.
Andrew Childers appearing on behalf of the people.
Mr. Jolly, can you acknowledge that you're there, sir?
Aw.
Time for court. Jolly.
Jolly.
Hey, Jolly, it's time for court. Mr. Jolly.
Jolly, jolly, ring.
Okay, he is present. I do see him. This is on the findings. So I'm going to assume there is no other additional evidence from defense. Is there any additional evidence from the people?
I have nothing on behalf of the people.
Mr. Jolly.
All right. Based upon the report submitted to the court will find that the defendant is competent to stand trial.
Okay, I have a couple Q's here, and I'd love some A's. Not you, sweetie. Hold on. Wait. Still. Okay, okay. I have a point. She kind of looks like the Penguin in Batman. Let's go over to our boy Jolly here. Now, I'm a little concerned at the kind of liquids that are on the floor of our boy here. You notice that? Yeah. Got that, and then we got that. That's a little concerning. I don't know if he's following his proper hygiene. Just saying.
Specifically, that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. What I will do is I will adjourn this out for a probable cause conference. Mr. Jolly, do you wish to be represented by an attorney?
Jolly, can you hear the judge talking to you?
I'm sorry? He's not acknowledging anything. What I will do at this point is I will just set this for a probable cause conference. I'll set it for March 6th, 2025.
It's not living up to his
9
namesake.
a.m. I will at that time advise him of the perils of self-representation. I won't do it today. So.
Oh God, Jolly's repping himself.
All right, thank you.
Thank you, Your Honor.
Cody Jolly. Ooh.
Court does call the case People versus Daryl Hicks. Or Daryl Hicks.
Good morning, Your Honor. Any for the people?
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Hicks.
Your name, sir?
Daryl Hicks.
Thank you.
Your Honor, we're just waiting on some continued discovery. Received an email yesterday that it's en route, so it's going to be the last adjournment.
Probable cause conference, February 27th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you. Court calls case People versus, is it Cameron Brown?
Any other makeup, sweetie? Or are you done?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Brown. Mr. Brown, please state your name.
Cameron Brown.
Your Honor, we're asking for an adjournment. Ms. Curry is going to speak to the complainant in this case about a potential resolution.
You believe it. Probable cause conference, March 6th, 2025, 9 a.m. bond continued.
Thank you.
Thank you. Thank you, sir. So, did you talk to her about moving furniture? Yeah, Maggie. Oh, well, now she just started picking up furniture and moving it around the court.
Well, the feng shui of the courtroom was off.
She didn't ask anybody. She just, like it was her house, redecorating. Huh?
Yeah.
You didn't see?
I'll take that.
Oh, you told her to get away from you, take the chair? Is that what happened? Okay. All right, I get it. Okay. Court calls the case, People versus Christopher Miller. Get away from me and take your chair with you.
Don't want the
Andrew
stupid
Chilton,
chair.
on behalf of the people.
I don't want that
Good morning,
chair,
Your
that
Honor.
chair,
Andrew
that
on behalf
chair.
of
I want
Christopher Miller.
that chair.
Your name, sir?
Christopher Miller, sir.
Thank you. You're requesting an adjournment.
Yes, I'm looking to obtain the video, and I've spoken to the prosecutor about that.
Not objection, probable cause conference will be adjourned to February 27th, 2025, 9 a.m. bond continued.
May I say one thing, sir?
Okay, go ahead.
Your Honor, you would like to address bond just briefly.
Oh, okay, go ahead.
I'm sorry. I'm gonna say this myself, sir. So I did mess up, sir. I was nervous about going to jail, and I did mess up and take a shot, and I would say that. But I did have a lot to think about while I was in here last, on account of.
Did you?
Yes, because what had happened was something that happened to my wife while I was in there. She had a miscarriage, and I wasn't even able to be there for her while she was in there. So that kind of like really sunk in that I messed up this time, especially after you gave me a chance, sir. So I was just trying to see if I could possibly get a new honor, try a chance to show you.
Mr. Miller, so that we're clear, Mr. Druk has made a very eloquent argument for you. It would be typically something where I would have blocked you off. I got sort of wooed by Mr. Druk.
Peekaboo.
I let you go, told you needed to go over and to test.
Yes, sir.
Sitting in my chambers. Wasn't 20 minutes. You went over and you blew numbers. If I had done what I normally did, we would probably not known that you had been drinking, but I did.
Yes, sir. I understand. Like I said, I've just really been trying to take care of this situation. That's why I turned myself in on it. Like, this is something that I wanted to address because I do have a good job, sir, and I'm trying to get everything taken care of. And I promise you would give me another chance.
Twice. I gave you a break the first time. You messed that up. You were standing before me after having drank. I let you go over. You tested positive. I'm not changing your mind.
Yes, sir.
Thank you.
Thank you, Your Honor.
That is why Drukas wasn't speaking. There was nothing to say. Court has called the case. People versus Ernesto. We got two cases.
Ashley Lonnie for the people in the armed robbery matter.
Big County for the people. 065.
Kind of looks like Chandler Halderson, too.
Defendant fellow Nicholas Bukovich on behalf of Mr. Alvarez in both matters.
Okay, what are we doing?
From my understanding, yesterday when speaking to Mr. Alvarez, he was interested in waiving his PE. I do have a PE waiver form here.
He's going to waive on both cases?
On both cases.
Is that correct, sir?
I'm talking to you.
Yes.
You're waiving your right to preliminary examination in both of these matters?
Yes.
Okay. You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
I think he bites the guard when they give him his meal tray.
That you'll proceed to circuit court for further resolution.
He's just waiting like home.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court in the case ending in 0065 on counts 1 and 2, and in the other matter on all 3 counts. I think.
It's going to go into court like Hannibal
On all 3
Lecter.
counts. Counsel.
Yes, Mr. Alvarez, may I sign the waiver form if you're permission?
Yes, Elmer Fudd.
Yes.
Be very, very quiet. I'm hunting rabbits.
We'll be standing mute and waiving the reading of formal charges, Your Honor.
Defendant having waived
rabbit
formal reading,
season.
standing mute to all 5 counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
February 26th at 1:30 before Judge Simpson.
February 26, 2025, 1:30, Judge Conlon.
And may I oppose to the sentencing waiver, Your Honor?
Yes.
God, those eyes are freaking me the hell out. Oh my God, he's creepy as hell. God, I need a better one, but here. Look at this. Ladies, imagine coming home to that at night. Rawr. Look at that sexual stallion there.
Thank you, so.
I feel like he's undressing me with his eyes.
Thank you, sir.
It'd be funny if the guard just goes and shuts his mailbox.
Court calls case People versus Dijon Ryan.
Bye.
Andrew Childers appearing on behalf of the people.
Don't we all?
Rob Chico on behalf of Mr. Ryan. Ashton, state your name for the record.
Aw, where'd my buddy go?
Judge, can we set this for exam?
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 25th.
Gonna have to write him a letter.
Childers, you were muted, probably, sir.
Sorry, Your Honor. Yes, that's fine. Thank you.
All right. Preliminary examination in person will be February 25th, 2025, 9 a.m. before me. Bond will continue at this time.
Huh?
Thank you.
Yeah. Hey, Drew, I'm going to give you a call later on, okay? Thanks, Judge.
Thank you. Court calls the case People versus Shana Coulson. Colston.
Alexander on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Coulson. Ms. Coulson, please state your name for the record.
Shana Coulson.
Okay, Samson.
Your Honor, we're asking to set this for a preliminary examination.
Discovery complete.
I believe so, yes, Your Honor.
Do people have their witnesses available the 25th?
We'll do our best, Your Honor.
All right. Preliminary examination will be set in person February 25th, 2025, 9 a.m. That's before Judge Barr. Before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case People versus Joel Helm Mormon.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Help. See you for the record. Your Honor, there is video outstanding in this case still. We requested it earlier this week. I believe it should be sent over to our office, but we just need a brief adjournment for that reason.
Probable cause conference will be adjourned February 27th, 2025, 9 a.m. Bond continues.
Thank you.
Case People versus Jeremy Davis.
Ready, Judge? Alexander on behalf of.
Oh, you were going to do something. No, I didn't know. I didn't know. No, I just thought you came in here trying to look pretty. I didn't know.
Thank you for noticing. Happy Valentine's Day. Early.
Your name, sir?
Jeremy Davis. Hands out your pocket. Torshell Feaster, Assistant Public Defender on behalf of Mr. Davis. Thank you, Judge. I have spoken to my client and to the people. This is the first PCC in this matter. If we could adjourn this so that we can have further discussions and try to see if we can reach a resolution, get an offer in this case, Judge.
Probable cause conference without objection will be adjourned March 6, 2025, 9 a.m.
Thank you so much, Judge.
Thank you. Bond continues.
All right, be back up here.
Court does call the case People versus Deontay Powell.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Powell.
Your name?
Deontay Powell.
All right. What are we doing?
Your Honor, we're requesting an exam date. I have all discovery.
People have their witnesses available on the 25th.
I'm not available on the 25th unless it's in the afternoon, Judge.
Yeah, you know, you've been here. You said everything in the morning.
Okay.
So would the March 4th work then?
I have a jury trial that starts March 3rd. I have a jury trial that starts March 10th for the same individual. He has similar type cases. I did put in my calendar that I was available March 18th.
March 18th? All right. Any objection from the people on that day?
No, Your Honor. Thank you.
Preliminary examination in person. We set March 18th, 2025, 9 a.m. That is before Judge Barr.
You said Barn?
Barr. B-A-R-R.
Okay, thank you, Judge. My client does want me to address the current bond.
Okay. Go ahead.
Judge, we were asking for a 10% option. I believe that the court has cash or surety, no 10% option. My client's mom is here and other members of his family, Judge. He will be with his mom, Judge. I know that I anticipate that the prosecutor is going to talk about perhaps a prior case, but I don't believe he'll be in contact with a complaining witness. Thank you.
Yeah. Response.
Your Honor, I do object to any change in the bond. Should have counted these up, but there are almost countless prior domestic violence charges, many of which were dismissed, but some of which resulted in conviction to I appear to have been dismissed previously, to say nothing of other charges that are domestic violence adjacent that were also dismissed to include charges, things along those lines. Judge, I'll leave it at that. He's facing 2 felonies. He's obviously, in addition to all the DV counts that have previously been dismissed, at least two that he was convicted of giving rise to this felony. I'm unaware of any change in circumstances that would warrant any change in the bond. It's a grand jury will have to see. Stay as set.
At the time of this,
Respond. That's what we don't want to. We'll see. You're not getting.
he's got holds out of other courts, is what I see. He's got over 10 prior criminal convictions, 3 violent felony convictions, and 1 drug conviction amongst that. The other thing is, does he have an active PPO out of 22nd Circuit?
I'm not aware
Or
of that,
this.
Judge. I don't know. The prosecutor might know.
That's the information that I have before me. But taking all of that into consideration, the motion for bond reduction in this case is denied. The court believes the bond is set as appropriate. Bond will continue.
Thank you, Judge.
Thank you.
Thank you, Judge.
Court calls case People versus Jacqueline Jones-Washington.
Oh, we get one more looky. Hi. Ah.
Assistant Public Defender Asli Bashir here on behalf of Ms. Jones-Washington.
Ms. Jones-Washington, can you state your name?
Hi. He did that. Have you seen my mom?
What are we doing?
It has come to my attention that initially under a different name, and I did not see this initially, but there was a competency hearing on January 30th in cases 24F2-1087 and 24F2-1088. These are both felony cases that were before this court.
Before this court, when are they set?
There was a finding an order on competency, and Ms. Jones-Washington was found incompetent but restored.
Okay.
Yeah, and so I would like to adjourn pending the treatment for that competency.
Well, was she under a different name or what?
Yeah, I think initially it was charged under Jacqueline. It's with a C in the name. I believe that's been changed in the court system now, but.
So when are those cases, if it's the same person, it's set, if she was found incompetent, it's set for a competency review. When is it set for a competency review?
May 1st, 2025.
So what do you want me to do with this one? Adjourn it out to that date? I mean, because I can't do anything, presumably.
Yeah.
I don't have a finding of competency in this case, but I could send it along with that case.
I believe, I'd be happy to file an order of competency, a motion for a competency evaluation, but I understand that the client has recently been evaluated, so I'm.
Correct. All they do is send over the other report.
Yeah.
It would just attach to this file.
Okay, so I'll make sure to do that.
All right, so what I'll do then is I'll set it for probable cause because I would need to do that. You can send the order over anytime. I will sign it. I will set the probable cause for, what was her date? You said May 1st?
Yeah, May 1st, 2025.
I'll just set it for May 1st, 2025 at 9 a.m. Thank you. Thank you, ma'am. Court calls case People versus Buster Robbins.
Okay, and we started with that. So I'm going to end it here. There's a woman in the box. I'm going to send you all over to Sean. He starts in a few minutes. with the closing, I believe, day 12 of the ASAP Rocky felony assault trial. So, yep, redirect is set up for Sean. So I will be back tomorrow morning at 10 for Judge Fleischer, and I may or may not do something tomorrow in the afternoon, but I'll most likely stream on Saturday. So thank you guys for being here. It's been a lot of fun. And, yep, I will see you guys soon. Alrighty, bye.